filed with the Secretary Treasurer. Sorry, I got on my screen again. I've got something coming up. The notice of appeal for a minor variance application must be filed with the Secretary Treasurer within 20 days of the making of the decision. The notice of appeal for a land division application must be filed with the Secretary Treasurer within 20 days of the mailing of the notice. The Secretary Treasurer for the Kenora Planning Advisory Committee is Melissa Shaw. The City Planner is Kevin Sumner. And do we have anybody doing the minutes tonight, or Melissa, you're doing them? Okay. I just got to see if I can clear this off my screen. Okay, good. We'll call the meeting to order, and we'll ask if there's any additions to the agenda.
Under new business, we'd like to add discussion around the September 2020 meeting.
Okay. Declaration of interest by a member of this meeting or at a meeting at which a member was not present. Seeing none. Adoption of the minutes of a previous meeting of July 21st, 2020. Are there any questions or corrections to the minutes as circulated?
I will note that I did receive amendments by way of member Bev Richards, and I have updated the minutes, some clerical errors.
Anybody else? Okay, minutes are approved as corrected. Ask if there's any additional correspondence relating to applications before the committee this evening.
I did circulate some correspondence earlier today. The first one being the approved entrance permits from the Kenora Roads Department regarding both lots that we are considering for consent this evening. So we are striking that as a condition from approval on D10-2003, application D10-2003. The condition has already been satisfied, so no need to require it. In addition, we did have some questions surrounding legal description. So City Planner will undertake to amend and review the proper legal descriptions with the committee here this evening. And then later this afternoon, we did receive requests for Plan 23R 10898. That was added to the planning report in error. That was just a follow through from a previous application. I did attempt to send that plan to committee members this afternoon, and I had bounce backs. So I do apologize. There seems to be something going on with my email. However, I can confirm that that is not unfortunate as these applications here this evening.
Okay, thank you. So we'll move on to consideration of application for minor variance D13-2003 and concurrently consideration of application for consent D10-2003. Estelle, are you going to do a presentation on your applications?
Yeah, I just have a brief little presentation.
Okay, go ahead, please.
So, good evening. I'm Estelle Kenora. I represent myself and Greg Hertz on these jointly owned properties, application D13-20-03 and D10-20-003. One's 13, one's 10, yes. We're seeking the city's approval for consent application and the concurrent application for minor variances for two abutting properties, concession 3J, part lot 56, pin 421780011, being 17.3 hectares, and concession 2J, lot 6, pin number 42178-0031, being 15.6 hectares. The overall purpose for this application is to be able to move forward with establishing these two lots as two separate and independent lots. They've historically been part of the Hertz properties for over 100 years, and we wish to make them available to other interested family members. We were initially under the understanding that these properties existed separately as they have their own access, tax roll numbers, and pins, and therefore they could be transferred as such. but we came to learn, as they're registered to the same named owners and have a section that abuts, they would be considered as one. Therefore, we are here to seek approval on our application for consent and the concurrent application for a minor variance. The concurrent minor variance is being sought for concession 3J part of lot 5-6 and under pin number 42178-0011 to seek relief from the City of Kenora's zoning bylaw, which requires 90 meters frontage for rural zoning. Approval for this minor variance would allow this lot to have a reduced frontage of 11.42 meters. As outlined in our minor variance application, our existing frontage on a public road, being Highway 17 East, was acceptable in its time, as 33 feet was then what was deemed necessary as frontage onto a public road. We've worked diligently to meet all the criteria to move these applications forward, and want to note that the professional support we received through the various City of Kenora departments has been very positive. We will continue to work on meeting these terms outlined to gain the final endorsement for these applications. Thank you.
Okay, thank you.
Did you
Kevin?
require my address?
No, we're fine. No, we're good.
Okay, thank you.
So we'll move ahead with the planner. Kevin, you go ahead with your planning report, please.
Yes, thanks. So as noted, this is a report that concurrently addresses both D10-2003 and D13-2003, the application for consent and the application for minor variance for the property with an unassigned address located off of both Whitehead Road and 7468 Highway 17 East. There was some questions of the legal description, and I trust that everyone received the updated and clarified legal description and property identification numbers that I sent out earlier today. And after sending that out, I did notice it was brought to my attention that the description for the northerly lot, I started off with parcel 1367. It's actually parcel 10367. So our meeting records will correct that. And the second, the lower parcel, we identified the PIN as 42178-031, and it is correctly noted as 0031. Dropped a 0 in there. But there was no question in our minds. The notification showed the correct parcels, and we have no concerns about the ability to move forward as long as we do note these correct legal descriptions on a go-forward basis, and the meeting minutes will show that. So the application for consent is proposed to create the one new lot out of the northerly parcel of the two that are adjoining. The effective approval will be to divide what is currently a 32.9 hectare property into two separate lots, the northerly being 17.3 hectares and the southerly being 15.6 hectares. The southern lot will retain the existing frontage on Whitehead Road. The northern lot will have a frontage on Highway 17 East that is less than the minimum frontage required, as Stella's already touched on, in the RU rural zone. Therefore, the application is being considered concurrently with an application for a minor variance, reducing the minimum required frontage for a lot in the RU zone from 90 meters to as Stella had requested, 11.42 meters. You'll note that throughout the report I've referred to 11 meters, and that would be my professional recommendation. Through years of experience, I've found that when going to the level of detail of 0.42 meters, which is measuring by centimeters, you can run into difficulties with rounding errors, and if you ever vary by even a centimeter more than what something ends up being, you can end up with an applicant having to come back for further variance. And it is worth noting that when we measure lot frontage, it's actually measured at a depth equivalent to the front yard requirement of a property. So even though that front property line was surveyed out at 11.42 centimeters. I don't have a guarantee that if we move back 25 meters from that front property line and measure a parallel line, that it'll be exactly 11.42 meters. So it'd be my recommendation that the committee do a variance to 11 meters to remove any possible complications due to rounding errors or adjustments in the future. And this will be something you'll see from me in variances of this nature. Just my professional experiences taught me to remove any potential obstacles that we can avoid to applicants for situations like this, to avoid having to bring anything back in the future. Moving on, all other provisions of the zoning bylaw will be met within the RU zone, and we have no other concerns about zoning. Moving on in the report, in regards to existing conditions, the property is designated rural within the official plan and zoned RU in the zoning bylaw. Neighboring uses are predominantly large rural properties to the north, west, and east. A mixture of rural properties are rural residential, light industrial, and highway commercial are located along the Highway 17E corridor to the southwest. The property is predominantly tree covered with significant areas of steep slopes in the northwestern and southern portions of the property. And we have included an image in the report illustrating the topographic lines of the property. And they're just to illustrate the sloping nature of large portions of the property. And there are no structures currently located on the property. As supplementary information to the completed application, an approved layout for hydro utility and a copy of an approved permit for septic field were received by the city along with the application. And although the lots are currently vacant, the proposed lots are being considered for new development. I did conduct a site visit on August 11th, and I took a couple of photos showing the area of the proposed frontage for the northern lot and the southerly boundary of the southern lot along Whitehead Road. It is a very heavily forested parcel, so I didn't see any point in going into the property to take any further photos, expecting you'd see more trees and some cleared areas throughout, and there is no current development as noted. In regards to consistency with legislated policy and city directives, in regards to the provincial policy statement, the application is considered to be generally consistent with the policies of the Provincial Policy Statement 2020, which promotes managing and directing land use to achieve efficient and resilient development and land use patterns. The proposed lots appear to be compatible with the rural landscape and appear to be sustainable by rural service levels. In regards to the City of Kenora official plan, the land use designation of the property is rural area, which provides for a variety of agricultural, residential, industrial, commercial, recreational, tourism, and open space uses. A portion of the northeast corner of the property has been designated as a potential aggregate area as illustrated in Figure 4. The surrounding area includes a variety of residential, industrial, and commercial uses and large areas of undeveloped land. Most adjacent properties are also designated as rural area, but several neighboring properties to the southwest has been designated as a commercial development area along the highway corridor. And I've noted policies of section 5.5.1 of the official plan, which provides policy directions for areas with aggregate resources, which will affect future development of the property, although they don't directly pertain to the immediate land division or variance concerns that are being considered tonight. Section 8.11.4 of the official plan provides policy for the creation of new lots, which is more directly applicable to our considerations tonight. The consent and subdivision / condominium granting authority shall be guided by policies of this plan governing minimum lot size and the following policies when considering land severance approvals within the city. And the section 8.11.4 does list a long list of criteria but only items H and I were considered to be relevant to the deliberation tonight. Specifically H, a lot creation shall only be approved when point 1, the newly created lot as well as the lot to be retained has permanent frontage with reasonable access to an existing public road which is currently maintained for year-round traffic. Point 2, the access, drainage, and other conditions for development are satisfied. Point 3, the impact of lot creation and on timber and mineral resources, fish and wildlife resources are mitigated. And point I, in areas without municipal servicing, new lots shall generally be a minimum of 1 hectare. And moving on to the zoning bylaw, the property is zoned RU rural zone. Development is subject to the regulations of section 4.1 or 4.12 of the zoning bylaw. Section 4.12, sorry, error in editing error there. Lots in this zone must have a minimum lot frontage of 90 meters and a minimum lot area of 2 hectares. And as noted earlier, a minor variance will be required to produce the required lot frontage. Single detached, mobile, modular, and seasonal dwellings are permitted uses in the RU zone. As per the planning rationale provided, the realigned lots and the stated future use of the lots will comply with the regulations of the zoning bylaw. You will see in section 6 of our report the results of interdepartmental and agency concerns. The only real comments we received were from Kenora Fire and Emergency and from the Roads Department, specifically in regards to the road access to the northerly lot. The concerns expressed in the original circulation have since been addressed, and I'm happy to say that there has been an entrance permit issued as of today, which removes those concerns or addresses those concerns, and will also has resulted in us in slightly amending our recommendation to remove the condition for the permit to be issued, since it's already been issued prior to this meeting. In regards to public comments, circulation of the notice was done to neighboring property owners as required under the Planning Act for both the consent and the minor variance. And there were no comments received as a result of that circulation. And as you can see, no one has registered to speak from the public in regards to either of the applications. Moving on to evaluation. In regards to the application for a minor variance, it is my opinion that the provisions of the RU zone provide for a 90-meter frontage. Section 3.15.5 of the official plan states that new development shall be assessed on compatibility and coexistence with existing development without causing undue adverse effect or impact on the surrounding properties. And it is my opinion that the proposed development for the creation of a lot with reduced frontage is compatible to the pattern of surrounding community and would not cause adverse impacts on neighboring properties. And the 4 tests are noted there for application for a minor variance, which I'm sure you're all quite familiar with. And we have no concerns in regards to any of those criteria. And in regards to the evaluation of the application for consent, if approved, the proposed lot line adjustment, in our opinion, or my opinion, will allow for transfer of ownership to 2 separate owners and the eventual development of both the northern and southern portions of the property. Therefore, the application is supported by the policies of both the provincial policy statement 2020 and the official plan, and is compatible with the regulations of the RU rural zone of the Kenora zoning bylaw, with the exception of the lot frontage requirement for the northern parcel, which requires the aforementioned minor variance, decreasing the required lot frontage from 90 meters to 11 meters. I've noted here the legislative framework for consent approval, listing out the criteria for that are to be considered in consent approval. Without going into detail, we have no concerns in regards to any of the criteria listed that we believe need to be addressed. Therefore, moving on to recommendation. In regards to the application for minor variance, we recommend that, or I recommend that the Kenora Planning Advisory Committee take into consideration, though any comments that may yet to be received, which doesn't look like we're going to get any, and that the application D1320-20-03 to seek relief of 75.58 meters from the City of Kenora zoning bylaw 101-2015, section 4.12.3A, which requires a minimum lot frontage of 90 meters for properties zoned RU rural zone. The effect of the approval would allow for creation of one rural zoned lot with a reduced frontage of 11.42 meters on Highway 17E. The application meets the 4 tests and should be approved. And as I noted before, I am recommending that the variance actually be to 11 meters to provide that wiggle room, as I professionally refer to it. And moving on to our recommendation for the application for consent D10-20-03. I recommend that application D10-20-03 for consent for lot severance on property located at unassigned address located off Whitehead Road and 7468 Highway 17 East, and legally described as noted in the email that I sent out earlier today, be approved and provisional consent be granted subject to the following. 1, the original executed transfer/deed of land form, a duplicate original, and 1 photocopy for city records be provided for each parcel. 2, a schedule of the transfer/deed of land form on which is set out the entire legal description of the property identification numbers in question and containing the names of the parties indicated on page 1 of the transfer/deed of land form be provided for each parcel. 3, that a minor variance is approved, reducing the required lot frontage of the northern property be reduced from 90 meters to 11 meters. As I noted earlier, we have removed the recommendation that there be a requirement for an application for an entrance permit. And also, as we've received them, we've also removed the original recommendation of original copies and PDF copies of the reference plan of survey. So the next recommended condition, it would be 4, that the payment of any outstanding taxes, including penalties and interest, and any local improvement charges, if applicable, shall be paid to the City of Kenora. 5, that prior to endorsement of the deeds, the Secretary Treasurer shall receive a letter from the owner or owner's agent/solicitor confirming that conditions number 1 through number 3 now have been fulfilled. Clearance from the City of Kenora and external agencies as required are to be included. And 6, that all costs associated with extension of services, driveway installation, surveys, legal fees, and matters related to the application are the responsibility of the developer/applicant. With that, that brings a conclusion to my report. And I can't remember if Melissa already noted in the report there was a reference to an attachment that shouldn't have been included. It was meant to be deleted. So there was a reference to a reference plan that was not in regards to this particular application. So just note that that was to be that was an error, not a part. The attachments were the complete application and the notice of application and public meeting, which you should have received. With that, that concludes my report. I would be happy to answer any questions.
Estelle? Estelle, I'm just going to come back to you. Is there anything you'd like to add at this moment?
I just have a few clarifications, but if it's all right with Melissa,
Yeah,
can I contact you personally?
Pardon me?
Can I just have a couple of things to clarify after the fact? So can I contact Melissa directly to just ask these questions, or is it Kevin or?
Sure, or if they're related to the application, you may also ask them now and then they will be on record. But that's up to you. Is it just the process after? Yes,
it's the wording in some of the points there that I got to make sure when you're asking for the registered owners, is that Greg and I currently, or when we're transferring it?
Right. So Estelle, this is a lot of the work that your solicitor will undertake to provide the city with the transfer agreements or the transfer documents we need to consent to actually allow you to transfer those properties. So we certainly can discuss that after, or I can be put in contact with the agent that will be representing you.
Okay.
Okay,
So
You're good?
it's not Greg and I's information you need again. It's the,
No, your lawyer will be providing us the information we require.
okay. So then that's pretty much my question.
that's good. You'll note that there's no one from the public to speak in favor of or against the application, so we'll go directly to the PAC members. And Bev, we'll start with you.
I have no questions. Everything's been answered. So thank you very much.
Tanis, you're muted, Tanis.
I was
There you
pressing
go.
the wrong button. No questions.
No questions? Okay, John McDougall,
No questions, Mr. Chair.
John Barr,
Just a quick one. Good point on the 11.42 to 11. That makes complete sense to me. But I may have missed it in the material, but the 11-meter wide frontage on Highway 17, is that part of the northern portion lot already? Or who owns that little piece that comes off the northern portion towards 17?
Yes, that is part of the northern parcel at present, or part of the entire property, if you want to consider it as such. But yeah, it's not a new addition to the parcel.
Oh, I just looked a little odd, sort of stuck there. Okay, no further questions beyond that.
Robert,
No questions, Mr. Chair.
no questions? Okay, I have no questions as well, so we'll move directly to discussion. So let's go. Robert, do you want to lead off in discussion? No, I think you're muted, Robert.
No, I don't believe so. I have no questions, Mr. Chair. I'm showing is not muted. Can you hear me?
I can barely hear you though.
I have no questions for the applicant, Mr. Chair.
Okay,
Or
how
no
about
discussion. No discussion as well.
Okay,
No, thank you.
Bev?
I have no questions or concerns. Thank you.
Tanis?
I have no questions or concerns.
Okay. John McDougall?
No. Go ahead.
No questions or concerns. Thank you.
John Barr?
No further comment.
Okay, everything's good. Okay, if there is no further discussion, no further questions, we'll need a motion, and we'll do a motion for the, would be first for the minor variance, D13-2003. So I need somebody to put a motion, do the motion.
Mr. Chair, I'll make motion that application D13-2003 be approved as amended in the staff report, Mr. Chair.
Okay, thank you. Seconder?
I second.
Okay, Tanis is seconder. Any further discussion? Any further, okay, all in favor? Okay, that's everybody. Okay, thank you. Need a motion for the application for consent, D10-2003.
Mr. Chair, I'll make motion that application for consent considered of approval D10-2003 be approved as amended in the staff report, Mr. Chair.
Seconder?
I can second.
Okay, John, you were in there first. John McDougall would be the seconder. Okay. All in favor? Okay, it's carried. Okay,
Okay.
so Melissa,
Yes, I will interject. Estelle, so applications for minor variances, you do receive a decision here this evening. It, however, is still subject to a 20-day appeal period from this evening. So on September 7th, I will send you notification as to whether there were any appeals made or not. Thereafter, then the minor variance, it stands. You've received provisional approval for your application for consent this evening for the creation of one lot. And as you and I can discuss offline, there are some next steps, a few of those conditions that we have listed to grant final approval. It is also subject to a 20-day appeal period. And that's after I provide notice of the decision here this evening, which will occur on Thursday, August 20th. So that will take us to an appeal period of September 9th. So thereafter, September 9th, both of these applications will be done their appeal period, and we will be able to engage with your lawyer on the completion of that consent application.
Great.
Okay. Okay, so Estelle, we're going to move on. If you want to stay in the meeting, you're welcome, but your application is complete.
I will leave. Thank you.
Thank you. Okay. New
Thank
business.
you very much.
Okay, you're welcome. Under new business, Melissa?
Sorry, I'm muted here. Under new business, we did just want to take an opportunity to discuss the September meeting. As Adam had explained in our July meeting, council will be moving to in-person come September. I will leave it to this committee to have discussion as to how you would like to see our September meeting occur, whether you would like to continue with Zoom in the interim, or if you would like to attend Operations Center to conduct an in-person meeting. On the topic of the September date, as of today, we have had 3 applications come forward in very draft form, but that would very much like to see a hearing in September. The September 15th date may not allow us to comply with the legislative requirements for notice, but if the committee is willing, we could look to reschedule to either the following dates after September 15th, being either September 22nd or September 29th. My preference would be September 29th if your schedules, are available. But again, that conversation should also be had as to the format. Would you like to see us to have an in-person meeting or continue with our virtual meetings?
All right, so we won't make that decision tonight, right?
I can certainly send this in an email and ask for you to respond with your preference, whether in person or virtually, and which date would work for you.
Okay, does that work for everybody, or
would you like to have discussion here this evening?
Well, I can just throw out, I'd rather keep it virtual, and my schedule's not open on the 29th, but I could do the 22nd.
And myself, virtual is working fine for me, and either date is fine. Whatever's for everyone else.
Robert, what do you think?
I'm just looking at my schedule. I'll be just, the 15th is probably going to be pretty bad, Mr. Chair. I'll be just in the beginning of my annual shutdown at the mill, try and install some robots. And the 29th, if I do my job well, I'll be available. I don't know. Doesn't look good.
September doesn't look good for you. The 22nd isn't an option either, Robert.
The 15th would be awesome. The 22nd, highly unlikely. That would be the second day of my annual shutdown. Tuesday, the 29th, I should be wrapping things up and the robot should be doing as they're told, but there's too many variables in that. So I'd be probably a 50-50 shot on the 29th, Mr. Chair, through you.
Okay.
And I'm either or, virtually or in person. Both are fine.
John McDougall, what do you think?
I'm good with virtual or in-person meetings. And on the 29th, I have a conflict, but any other date is good. And if it even rolls later that week or the following week into October, I wouldn't have a problem having 2 meetings in October if that needed to happen. But I'm pretty flexible. The 29th isn't ideal.
Okay. John Barr, what do you think?
Well, anytime after the 21st, I'd be doing the meeting virtually from Ottawa. So I have to leave town for a little while on the 21st. So I'm not available after the 21st except virtually.
Okay, would you be willing to attend virtually from Ottawa, John?
Absolutely, sure.
Okay,
And I myself would like to do virtual as well.
okay.
And I think I'm all right, whatever the decision is. I think I'm fine.
Okay,
I'm out of town starting October 2nd, but that's it.
okay. If it's okay with the committee, I will propose a virtual meeting on September 22nd. And that will at least allow me the opportunity to have discussions with the agents making application, to have them submit complete applications, and we will start the process for circulation.
Yeah, actually, I just realized September 29th, I'm in Thunder Bay and wouldn't be available.
Okay.
Okay, so we're gonna aim for the September 22nd?
Yes, I will run that by Kevin and Adam to ensure there's no concern there, and I will send out an email confirming date change.
Yeah, and run it, like, we'll see what Ray has to say as well.
Yeah, the 22nd, I expect I'll be in Sault Ste. Marie on the road, but I could probably do it if I'm there before 5. However, whatever,
Yeah, we'll see what the response is, okay.
sure.
But Robert, that leaves you out, right?
Well, it doesn't necessarily leave me out. It's just that there's no reason why. It'd probably be at 6 o'clock again. So, I mean, you might hear me yelling at a couple robots in the background if that's okay. I could probably remote in from work, but
Would
we'll see.
it make things easier for us to push it back to a later?
Well, then if we go 7, we try seeing 3 applications. and
Yeah,
that
we
kind of
may
stuff.
have 3 applications.
And if things go bad for me, I'm going to be off the grid all day and half that night. So I'd hate for the rest of the committee to wait for me and then not show up. I think that would be pretty rude.
Okay. Okay, I will
So-
propose September 22nd at 6 o'clock.
Yeah, and then if we have quorum concerns, maybe I'll just need about a day's notice, and then I will mitigate that if we have to, if we have quorum concerns as well.
Okay. Okay, with yourself and John Barr being potentials, I will have to see what Ray says.
Okay.
We should be okay.
All right, anything else?
That's all that I had.
Okay, so, John Barr, do you want to adjourn the meeting?
Meeting adjourned.
Okay. Robert,
Yeah.
would you mind giving me a call after the meeting on my cell?
Yeah, I should have it here, Wayne. Just let me take a look here. Oh, yeah, I got you, Wayne, I think.
Night, yeah,
Good night.
night, everybody.
Bye, everybody. See you next month.
Thank you.